Okay, just quick introduction. My name is Tim Lohmar. I'm the St. Charles County Prosecuting Attorney. And we call this press conference today to kind of outline the reasons behind our decision not to retry Jonathan Irons. So before I get into that, just give you a little bit of a backstory. Back in 1997, Mr. Irons was charged here in St. Charles County with assault in the first degree, armed criminal action, and burglary in the first degree, arising out of a home invasion and shooting that occurred in the city of O'Fallon. Mr. Irons was tried on those counts and convicted by a jury, and he was sentenced to serve 50 years in the Department of Corrections. Since that time, he has exercised several of his appellate rights in an effort to get that conviction overturned, claiming that he was wrongfully convicted. In December of last year, the Cole County Circuit Court granted his petition for writ of habeas corpus. And what that means is the court set aside his conviction and vacated the sentence. At that point, the Attorney General appealed the case to the Western District Court of Appeals. That appeal was denied. And then just 2 days ago, the Supreme Court denied the Attorney General's request for further appeal. What that means is the case was then sent back to me. I had 10 days since this is the county in which he was tried. I had 10 days to make a decision to either retry Mr. Irons or to dismiss the charges. Yesterday afternoon, the Honorable Judge Deborah Alessi signed the order and memorandum of dismissal with prejudice, meaning the charges can never be refiled, and she also ordered Mr. Irons' immediate release. It's my understanding that he was released yesterday, just hours after the judgment was signed. That's the procedural history. Just want to dive in a little bit. I'm sure you guys may have some questions to tell you what the basis of our decision was. So when we knew that the Cole County Circuit Court had set aside the conviction, we knew there was some time that the appellate rights would attach, and so we'd have some time on our end with our investigators to do our own independent investigation, and we did that. My investigator to my right, Mike Harvey, led that investigation, interviewed every living witness that was available, or willing to testify, I should say. We reviewed the entire trial transcripts, and we came to the conclusion that there were certain errors in the trial and certain things that if we were to retry him again, it would be nearly impossible to do so and uphold our own ethical standards. I'll highlight three areas of concern for us. The first was testimony in the trial about fingerprints. The evidence at the scene showed that there were 2 fingerprints on a glass storm door at the residence. There were 2 different reports on those fingerprints. The first report indicated that the one fingerprint belonged to the victim and the other fingerprint was unidentifiable. The second report took it a step further and not only said it was a victim's fingerprint and an unidentifiable person's fingerprint, but it also excluded Mr. Irons. That second report, for reasons unknown to us, was never disclosed to the defense. That severely impacted the defense's right to a fair trial and certainly a right to put forth the position that someone else could have committed this crime. The biggest issue for us, I think, was the interview that was conducted of Mr. Irons. The detective who conducted that interview is now deceased, so we were not able to speak with him, of course. The problem that we saw was this: the interview was conducted one-on-one, detective and Mr. Irons, behind a closed door, no recording devices, nothing in writing, no written waiver of Miranda rights, no third-party witness to confirm whether Miranda was given. That is our view of that interview technique, as well as how it played out in the trial. That is a textbook reason why you don't do an interview that's not recorded. That protects not only the suspect, but it also protects the police. So that was a huge problem for us. So now, again, faced with the proposition of having to retry him based upon a confession, an alleged confession, where the person who obtained that confession allegedly is now deceased, would have been a virtual impossibility. The third big piece for us was the identification of Mr. Irons. The entire trial was based upon circumstantial evidence, and in addition to the alleged confession. There were several witnesses who placed Mr. Irons near the scene of the crime. Nobody placed him at the scene of the crime. There was one witness who allegedly told police officers that Mr. Irons admitted to burglarizing the home and shooting the victim. That witness is still alive. Our investigator tried to reach out to him, and he refused to cooperate and basically recanted his story. So you put all those things together, and we were faced with a relatively easy decision, which is we have a high ethical standard to not charge somebody with a crime or try somebody for a crime unless we know we can prove that person's guilt beyond a reasonable doubt. We certainly do not believe that we could prove his guilt beyond a reasonable doubt. So that's why we elected to dismiss the charges, let this truck pass by. Okay, I guess I'll entertain questions if you guys have any.
Tim, do you believe Mr. Irons is innocent?
I knew somebody was going to ask that question, and that's a fair question. We made it a point not to make a determination as to his guilt or innocence. Our objective was whether or not we could ethically retry the case, and in our view, we could not. We don't know whether he's innocent or whether he's guilty. We do know that we don't have enough evidence to prove that.
If you had to characterize that evidence, would you call it questionable, weak? I mean, what words would you use?
Both of those, questionable and weak. Some of the tactics that were used in this case were commonplace back 25 years ago. Our officers don't engage in interviews the same way these days. There's a statute that was enacted about 11 years ago, I guess, that requires interviews for serious crimes to be recorded. That didn't exist back then. I think we have, it's a different environment now. Back then, especially in St. Charles County, if a police officer testified to something, the jury took him at his word. I don't know if that's the case anymore these days, sadly, but that's a sad reality that we deal with. So yeah, it was just a pile of circumstantial evidence, no direct evidence, and when you're talking about the stakes that are this high, it was just an easy choice not to go forward.
Can we speak with your investigator as well?
I don't think so. I'll speak for him. Yeah.
Was it the homeowner who identified Jeremy Irons as the assailant in this case?
It was. So he was the victim, and I mean, clearly his home was burglarized. He was shot. There's no question about that. He was shot in the head. It was, I don't want to say it was a graze. I mean, it caused some severe damage, but he was able to remain alert. Initially, he had difficulty identifying Mr. Irons. He couldn't pinpoint Mr. Irons. Later, there was a photo array, we call it a six-pack, that was presented to him where there were six alleged potential suspects, I should say. There's a problem with that as well because Mr. Irons was included in that six-pack. His photo happened to be just a little bit larger than the other five. After that, he was able to positively identify Mr. Irons. And then, of course, as the human mind works, as time went on, various hearings and trials, his memory appeared to become stronger, if that makes sense.
Has he since recanted that ID? Or
No.
Is he still sticking to his identification of Irons as the shooter?
Yeah, he's still sticking to that. It's been 23 years now. As best he could recall, he believed that that's the person who invaded his home and shot him. And we don't fault the victim. In this case, it's hard to say, but I think that there was certainly an element of coercion, so to speak, maybe subtle coercion in how he was able to identify Mr. Irons.
Forgive me, I don't know all the details on it, but there were two suspects in the home that night, is that correct?
Just one.
Just one, okay.
Mm-hmm.
So then it would appear that there could possibly be the gunman who is still out there and has never been caught.
That's very much a real possibility. Absolutely.
Does that mean it's an open case? Or
No.
is it too old?
Just with everybody who was involved in it, a few of whom are deceased now, it would be virtually impossible to recreate that case. So this is, in the absence of something new that comes to my attention, it's a closed case and a dead issue.
As far as the evidence gathering, I mean, we're talking 25 years ago. This was not from the 50s or 60s. So when you look at it, it's a little surprising at the procedures and protocols that were in place a mere 25 years ago for something like this?
It seems like it today, but we look through the lens of here and now as we look back. Back then, we were just talking about this just upstairs as we walked down to do this. The tactics and techniques that were used in this investigation were commonplace 25 years ago. That's just the way it is. We've come a long way, for the better, no question.
Can you talk about some of the troubling writings that we discussed that the detective involved in this was accused of posting?
Yeah, so the detective who allegedly obtained the confession, he's now deceased. Years after the trial, he had some sort of web-based blog. I don't know if it was Facebook or what it was exactly, but in that he would write about tactics that he used when he was an officer to obtain a confession. There are also some racist undertones, if not overtones, in some of the things that he said. Those all came to light many years after the trial. And of course, if he were here to testify, he could be cross-examined on those things, and his testimony could be impeached, or credibility could be impeached, I should say. He's not here, so that again, that takes away another right to a fair trial.
So, in a nutshell, which is a little redundant, just so we have another version of it, what are you doing here today and why?
We have elected not to retry Mr. Irons, and we have dismissed all counts with prejudice, meaning they cannot be refiled. Yesterday, Judge Alessi signed an order setting him free immediately, and his sentence is vacated, and his time has been served.
And Tim, one other question. Can you just explain what vacating a sentence means? I mean, it's not, he's still a convicted felon, right?
No, that's a good question. You can't take away the 23 years that he had to serve, but on paper, his record is he is not a convicted felon. He has never been to prison in terms of his actual record now that this order's been put in place. He's a free man.
I suppose if you could find an attorney to file a case, you could file a suit on anything, but legally speaking, does he have any leg to stand on now against the state of Missouri or St. Charles City or County?
He's got a very qualified and respected legal team, and I would defer to them to answer that question, one of whom is right over here, if you want to talk to him afterwards. Anything else, guys? All right, thanks so much for covering this. I appreciate it.
We're gonna bring you up.
You guys, why don't we come over there?
If you could bring her here, that'd be great.
That's fine.
Better in the shade.
We're all set up here.